Hello, and thank you very much for joining us today in the latest in the series of our VWE sector series. Today we're going to be talking about subsidy control. I know that today's a very busy day with bonfire night in the US election going on, so thank you for coming. So I'm going to start the session today and provide an update. Apologies. The objectives of today's session is to provide you with an update on how the Subsidy Control Act is working in practice and what it means for the HE sector. The Act has been in force for coming up to 2 years now, so we're beginning to see some trends. So I'm going to kick off today and give a brief reminder, a canter through what is a subsidy and the process checklist for assessing if a subsidy gives rise to an issue. Hopefully this will be useful for those who are not so familiar with the subsidy control regime. I'll then look at some of the recent developments in statutory guidance and emerging themes coming from the new Labour government. And then we'll turn to look at some of the practices of the Competition Appeal Tribunal and the Subsidy Advice Unit. And my colleague Isabel will be joining us for that. And hopefully we will have plenty of time for questions and answers at the end. So, as I said, Subsidy Control Act has been in force for coming up to 2 years. It's much more permissive and flexible approach compared with the EU state aid regime, so that subsidies are not automatically prohibited. There are some exceptions to this rule. So, for example, if you've got an unlimited guarantee or subsidies are linked to import or export conditions or to restructuring aid, then they may be subject to conditions or prohibited outright. But there's a much more focus on self-assessment against compatibility principles, and that's really the responsibility of the public authorities who are giving the grant, and we'll talk about this a bit more later. But the quid pro quo for greater flexibility is obviously the increased transparency and notification obligations for even small levels of subsidy of over £100,000. So what is a subsidy? There are 4 elements that need to be met in order for a subsidy issue to arise, and these are cumulative tests. So you need to have financial support, which is given directly or indirectly from public resources. It must confer an economic advantage, and that's particularly important point for HEIs, and we'll come on to that in a minute. And there must be a selective advantage which favours an enterprise over other enterprises. And then you've got to have an actual potential impact upon competition or investment, either in the UK or a part of it, or between the UK and a country outside of the UK. So I've set out a list of the typical types of examples which give rise to a subsidy. So for many of you, you will receive grants from UKRI or from central government or a local authority. But other things to watch for are the supply of goods and services at preferential rates, making access, and that includes granting access to infrastructure or equipment at lower than the market rates, provision of free or subsidised advice or training or consultancies to SMEs or to other commercial organisations. And then we have got items such as equity contribution by a public authority or providing loans or guarantees, even if they're not called upon. And lastly, tax advantages where they favour particular sectors can be problematic, and they're very difficult from a subsidy control perspective. But there are certain things which are not subsidy, and they tend to arise out of the condition about whether a measure is selective or not. So measures which are available to all, for example, general taxation measures or measures that were available in COVID to everybody, aren't treated as being a subsidy because there's no selective advantage. And to the extent that a public authority may be acting as a commercial market operator, either through providing equity or loans, or through the or where there's a transfer of goods and services at market price, that also doesn't meet the condition for selectivity. But there's been quite a lot of discussion, and we'll talk about this later, about how you demonstrate the commercial market operator principle test. I'm going to go back to the top item on the list, which is just a reminder that where an organisation is discharging a statutory function, for example, education, and some types of research, that also is not treated as a subsidy. And sometimes carrying out a procurement process, if it is following a regulated procurement process, can be a defence to a subsidy. Now, on the next slides, I've just included a checklist for you to think about if you find that you might be in a potential subsidy position. Appreciate that I'm cantering through this first section very quickly, but as we've said, the slides will be circulated after today, and I wanted to get on really to the recent developments. The first question that you need to think about is which regime applies. So if you are entering into collaboration agreements with organisations in Northern Ireland, or if there's likely to be a substantial impact on a market in Northern Ireland, then it's just worth pausing, because it may be that the EU state aid rules apply rather than the rules under the Subsidy Control Act. So if you're satisfied that you are looking at the UK regime, then it's ticking the boxes for a subsidy to be met. Those are the 4 conditions we looked at earlier. Checking the prohibited list, and then seeing whether there are any legacy schemes which are available under the old state aid regime, or new schemes under the Subsidy Act which are available. And the subsidy database can help with that, although it's quite difficult to search, at least I find it quite difficult to search for information, but there are increasingly subsidy schemes available which will help fast track a subsidy if you can get it within the conditions. Then in terms of the next step, not particularly useful for universities, but where university might be flowing down aid to commercial organisations, it's worth considering if they might be able to use their minimum financial assistance allowance. So this is 315,000 of aid, which can be used over a 3-year period, but there are conditions that have to be satisfied in terms of paperwork in order that a beneficiary can accept aid as minimum financial assistance. It's worth looking at the streamlined route for research, development and innovation, which provides a safe harbour and exemption for certain types of low-level research and development commercial use. But there are a number of conditions that need to be satisfied if you are looking at this route. If all of those steps fail, then you've also got the opportunity of carrying out a compatibility assessment against the subsidy control principles to assess whether the conditions for assessment can be met. If you're looking at a subsidy which is over 10 million for a beneficiary, it can be less if you've got particular subsidies in a sensitive sector. Then there is a mandatory referral to the subsidy advice unit so that the SAU can examine the subsidy against the compatibility assessment and report before the subsidy can be implemented. And then finally, there's a requirement to publish on the subsidy database. This is actually a requirement on public authorities rather than beneficiaries. So, as I say, a quick canter through the basic principles. But in terms of particular issues for the HE sector, HEIs are in an arguably unique position because you may be acting with 3 hats on. You might be acting as a beneficiary, grant funding from UKRI, and it may be that you're collaborating with other universities or commercial partners, and that there will be other beneficiaries who, for example, may receive training or consultancy services. And the university's got to think about whether there's a subsidy position for itself or for any beneficiaries that it's flowing down aid to. It's possible also that an HE organisation can be a public authority who is conferring aid. So the definition under the Subsidy Control Act is quite wide, and it means any person who exercises functions of a public nature. And if you are a public authority for the purposes of the subsidy control rules, the tests are different between different legislation, talking about freedom of information and public procurement here. Then there are special responsibilities for you. The other point to note is that many of you will be carrying out both non-economic and commercial activities. Now, non-economic functions, fulfillment of such duties, don't tend to give rise to any subsidy control issues. It's more the commercial activities that give rise to the problems, because if you remember, there has to be a selective advantage to an organization, to a commercial organization, in order to meet the tests. But increasingly, as HERs are looking to balance the books, we're seeing an increase in commercial activity. We're also seeing projects that start off as non-economic, and then over time, there's a requirement for a project to be self-sustained, and it evolves into commercial activity. I think that possibly subsidy control for HEs also have a slightly different risk profile than previously. So on the next slide, I've set out some of the consequences of receiving a subsidy. So under the old EU state aid regime, if you had a subsidy, then it was automatically prohibited unless you could fit it within an exemption, and there was a requirement to repay it, and third-party complainants could bring an action for damages. Now, it's still possible for a third party to bring a claim in relation to an alleged subsidy through the Competition Appeal Tribunal. This is by way of judicial review, which means that there's no actually recourse for the complainant in terms of damages. What judicial review can do, and I set out the most common remedies here, is to provide a declaration that there is a subsidy and a prohibition against a subsidy being implemented, or to the extent it has already been implemented, quashing it. There is provision in the Act for repayment of a subsidy together with interest, but the guidance says that there's a lot of flexibility as to how that remedy is going to be used. And in reality, the greater risk of repayment of a subsidy is going to come for breach of a grant funding agreement, where you'd expect to see tight rules on compliance with subsidy control. And I think my view is that we're seeing a transfer of risk towards breach of subsidy being arising in connection with breach of a grant funding agreement that might arise, for example, perhaps in relation to an audit. There are also another number of other consequences of a finding of breach of subsidy, that it may impact upon the ability of the institution to seek further funding. There's obviously a lot of reputational impact, and there may be other agreements or financial covenants which say that breach of subsidy control rules will trigger a breach of those agreements themselves. So, all right, so now I wanted to go on to some emerging themes. October has been a busy month for the government. So it's given us an indication. There are two things which have given us an indication of the government's approach to research and development and subsidies. And on the 17th of October, the government published its modern industrial strategy called Invest 2035 in the form of a green paper. And this recognises that the government needs to ensure that the UK has a competitive offer across all of the factors that influence investment, which includes building on its world-class network of universities and research institutions. Now, there's a clear focus on a number of sectors, including advanced manufacturing, digital and technology, green and creative sectors. And I think those are the areas where we're going to see most investment and potential subsidies. There's a recognition that if the UK government doesn't provide subsidies to certain sectors, then it will have an impact upon the ability of UK PLC to invest and to manufacture. And some of these sectors translate through to some of the subsidies that we're seeing come through, which we'll talk about shortly. And then the budget last week. So the Chancellor reiterated the government's commitment to research and development to unlock growth industries, providing research and development with more than 20 billion worth of funding, including core research funding in the areas of engineering, biotechnology, and medical science. So clear indications as to where the key themes are. Okay, so on the next, one of the points that I've made on the previous slide, which I just want to pick up. Actually, there's 3 points that are worth talking about. I mentioned audit and the risk of a subsidy being discovered as a result of an audit rather than perhaps a third-party complaint. We're seeing a much greater focus, and indeed the Labour government have talked about efficiency and effectiveness in terms of audits to make sure that growth funding is working harder for money. There is a theme emerging about treatment of no subsidy. And at the moment, one of the issues is that if there's a no subsidy decision, that the core conditions are not met, there is no transparency of that decision-making process, at least no transparency from a public point of view, as opposed to the database, which has got transparency of subsidy control decisions. And there's a question as to whether there should be changes to implement that. One of the approaches that we're seeing, we're going to talk about some of the facts and figures about notifications of subsidies and referrals of subsidies to the Subsidy Advice Unit. And what we can see from that information is that there are very different approaches being taken by public authorities as to whether they decide that a subsidy should be notified as a scheme or whether to treat it as no subsidy. That makes it quite difficult when you're negotiating with a particular local authority or department, because there's no consistency. So on the next slide, I've set out some of the legal developments in terms of the statutory guidance. So the Subsidy Control Act sets out a framework, if you like, of the subsidy control regime. But interpreting it, you need to have regard to the statutory guidance. And this has been through a number of updates in the last year. The good news for beneficiaries is that there is a clear statement of intent that the responsibility for carrying out a subsidy assessment lies with the public authority giving the subsidy. And it goes on to say that the issue of whether a subsidy is consistent with subsidy control principles is not a matter for a beneficiary, but the public authority giving the subsidy or making a subsidy scheme. So we have noticed that the trend for requirement for public authorities to seek independent subsidy control opinions from beneficiaries has certainly been reduced. However, it's still important that where your organisation is receiving grant funding or a measure which might be a subsidy, that you carry out your own assessment. You understand the risks that I've highlighted earlier. And it's also really important that you make an audit trail of the checks that you've carried out and the considerations that you have taken for governance purposes. We'd also suggest that it's important that you liaise with the public authority giving the subsidy to discuss the approach that they're going to take, because you want to make sure that that's consistent with the approach or your preferred approach to treating a subsidy. And in fact, your input into some of the questions in relation to the subsidy assessment will be really important. Okay, so on the next slide, there's an update in the statutory guidance to the impact of the Durham decision for intra-group arrangements. Now, when I gave the talk on subsidy control last year, I talked about the first case which had gone in the Competition Appeal Tribunal, which was the Durham case affecting a subsidy in relation to waste by a local authority. Now, that case, I think, is still quite problematic and it's unclear, but what it does suggest is that where an organisation is carrying out both non-economic and commercial activities, that if those activities are all being kept together within a particular function, then there's no risk of cross-subsidy. And the reason for that is that if an entity is acting both as a public body and also carries out commercial functions, from a legal entity point of view, there's only one person, there are no two people, and therefore there can't be a subsidy. I think that it's still a strange decision, but that is something that may be worth looking at if you're thinking about structuring arrangements to avoid subsidies occurring. I think the better rule is still to rely on the 80-20 rule for research organisations, so that where at least 80% is being carried out for non-economic reasons such as education, research and development, or transfer of know-how where that access is available to the public, then if there's a limited ancillary amount of commercial activity, then that doesn't take the research organisation outside the scope of the subsidy control rules. But there's still very little guidance on any of these concepts. I mentioned about the commercial market operator principle earlier, and I wanted to mention a case which is upcoming in the Competition Appeal Tribunal. Next slide, please. Thank you. Which is the case of Aubrey Weiss against the Greater Manchester Combined Authority. Now, this is a complaint that has been brought by a third party against GMCA, and the complaint relates to the application of the commercial market operator principle. And the issue here is that two loans were given to property development companies as part of the GMCA Housing Investment Fund. And the issue is whether those loans have been made on market terms or actually are in fact a subsidy. And so it goes into the detail of what investigations and evidence GMCA undertook to satisfy themselves that the loans were on commercial market terms. Now, frustratingly, this case was being listed in July, and we're still waiting for a date for it to be heard. It had been hoped that the subsidy cases would be fast-tracked, but it seems to me that there's a hiccup on that at the moment. Okay, so we're now going to look at some facts and figures to see how the database is working, and some facts and figures regarding referrals to the subsidy advice unit. As I said, it's not easy to navigate around the subsidy control database. I've put a link in there for you for easy reference. When I spoke last year, there was just one entry on the database involving universities. There are now 82 entries in total. 33 of these relate to research and development subsidies, and the other 49, and that includes actually Horizon, which subsidies which have just been notified on the register, and 49 for other subsidies, including environmental and energy and infrastructure. So there's certainly been an increasing uptick on notifications. They've principally been made under schemes operated by local authorities or central government. What's also interesting, if you look at the information about a subsidy on the database, is that I certainly noted an increase in the levels of information that have been included about the subsidy. Previously, whereas you might have had a subsidy under a scheme and you just find a link to the web page which set out the details of the scheme, but now there seems to be a lot more information. And the reason why this is of importance to universities receiving subsidies is that the time limit for bringing a complaint in relation to a subsidy is 30 days from the date information about the subsidy became apparent. So it's really important that where you receive a subsidy from another public authority, that a notification is made in the proper manner. So I'm now going to hand over to Isabel, who's going to talk through some of the facts and figures regarding referrals by the Subsidy Advice Unit.
Hi everyone, I'm Isabel. I'm a solicitor in the team. So I'm going to just go over the actual role of the Subsidy Advice Unit. So they actually have quite a limited scope as to what they can advise on. So they're working on very tight timescale. So once they accept the referral, they've got about 30 working days before they publish their report. So like I said, their advice is actually non-binding, so that's very important to remember. Their role is more to critique rather than give sort of binding advice. So we'll go over some facts and figures on the next slides, but all of the referrals so far have been mandatory. So, sorry. Sorry. So yeah, all of the referrals have been mandatory so far. So they've been subsidies of interest or subsidies of particular interest. So another role of the Subsidy Advice Unit is to actually review how the Act and the new subsidy control regime is working in practice. So they're expecting to start this process early next year. So we should get the report the following year in 2026. So there's been a couple of suspected areas of improvement that they might focus on. So one of them is the actual usability of the database. So it's definitely mentioned previously, this is, I don't know how many of you have actually tried to navigate around the database, but it is quite tricky to find the sort of information that is helpful and to just navigate around it. Another thing that we mentioned earlier is that there's quite limited transparency at the moment of assessments where there isn't a subsidy. So the focus has obviously been on assessments of subsidies. So at the moment, there's no real way to view these assessments. So that is probably something that they might pick up on. Okay, so here we've sort of just done a breakdown of who is making the referrals and what sector it's in to try and give you a bit better understanding of the referrals. So this accounts for referrals made between 12th of January 2023 and last week. So the big winner here is energy. So that accounts for 20% of the referrals. Next is building and construction, and this includes infrastructure as well. So that accounts for 15%. I know that's probably of interest for the higher education sector. Also, that's something like communications. That might be quite interesting for higher education. So that is a much smaller amount. So that's only 3%. recreation and leisure is 14%, and then transport is 11%. So it's quite a big range of sectors. And then we will look at who is actually making the referrals. So this shows a breakdown of the referring authority. So I think when this process was first started, it was thought that the majority of referrals would be from central government. So obviously you can see here that 39% actually came from local authority. So that's a much bigger number than I think people were expecting. So that's been a bit of a surprise. It'll be interesting to see if that carries on or so. Next is a breakdown of, again, who is making the referrals, the referring nation, sorry. So you can see here that the vast majority are coming from England, so 81%, but actually Wales are making 11% of the referrals, which is actually quite high. But this does sort of mirror the approach of the Welsh government and how they view funding and how they treat subsidies. So they're quite pro-subsidy. So that reflects quite clearly in this data. So I think I'm going to hand back over to Stephanie now, and she's going to go through some more specific subsidy advice referrals, focusing on research and development.
Thanks very much, Isabel. We thought it would be useful to give you a break from hearing my voice. So there have been 4 SAU referrals involving research and development since the subsidy regime came into force. And I thought it would be interesting to look at some of these. One of the referrals is still pending, and I'll talk about that in a minute. But the 3 schemes which have been reported on involve the Life Sciences Innovation Manufacturing Fund, which is about pharmaceuticals, the Connectivity in Low Earth Orbit Programme, which is about communication, and the National Nuclear Laboratory Subsidy, which is about energy. So I'm going to start first by talking about the Connectivity in Low Earth Orbit program. And this is a subsidy scheme providing 94 million of grant funding to support research and development for firms based in the UK to develop low Earth orbit satellite communications capability. And when the SAU is looking at referrals, as Isabel mentioned, they have quite tight scope for assessment. So they're focusing on 3 steps. Step 1 is to identify the policy objective to ensure it addresses a market failure or equity concern, and to determine if the subsidy is the right tool to use. So there are 3 elements within that, which is you need to describe the policy objective and explain whether this arises because of either a market failure or equity concern. And then you need to show that you've considered all of the possible range of measures that can be taken to address the policy objective and why you've chosen a subsidy. And then step 2 is about ensuring that the subsidy is designed to create the right incentives for the beneficiary and bring about change, i.e. that the change wouldn't have happened anyway without the subsidy. And then the third one is really a competition assessment to consider the distortive impacts that the subsidy may have and keep them as low as possible. And so when the SAU reported on the connectivity in low Earth orbit program, they said that the policy objective of the research and development scheme was to clearly accelerate the commercialization, rapid industrialization of key technologies, and to ensure that UK firms had a significant and sustained share of contracts, and to develop UK's industrial capabilities in this area. And without it, it was likelihood that there would be a sort of brain drain of people in this area, and that would be lower investment. And this was a sort of key target of the government. This program is, well, this subsidy report is useful because it echoes many of the themes that we are seeing in relation to subsidy programs. It relates to connectivity in space, but it could relate equally to other areas of research and development. Some of the criticisms of the SAU was that there needed to be further evidence to support the reasoning regarding market failures, that the approach set out in the subsidy guidance wasn't strictly followed in the report. And another theme that is a constant issue, that when you're demonstrating the balancing effect, you need to set out the negative effects on competition and trade, as well as the potential positive effects. And then the latest referral involving the pharma sector. Isabel, sorry, if you could whiz back before we get to BioNTech. Thank you. Is the Life Sciences Innovative Manufacturing Fund. So this is a very high value fund. So this is up to, checking my, I think this is a scheme of 500 million, budget of 520 million to be delivered up until 2030. And it comes about to bring the government have identified a shortage in the UK's ability to manufacture certain medicines, and also the need to improve health resilience. And it is aimed at projects that will manufacture human medicines, medical diagnostics, and tools. And again, in terms of the evaluation of the SAU, there's mention that other countries are providing subsidies, which has led to a decrease in the UK's manufacturing capabilities. And so the UK is losing out on opportunities to exploit innovation and achieve economic growth. It's also saying that this is an area, as we've talked about in the emerging themes section, that the government is very keen to protect, or and to make sure that it's adequate investment. And so there was a comment in this report about the analysis of affected markets. There were lots of markets affected, and the SAU felt that the actual markets hadn't properly been defined, and they said there was a lack of supporting information to actually back up some areas of the report. It is difficult when you're looking at referrals to provide any specific areas to look out, because we only get a snapshot of the information. But there are some recurring themes that I've mentioned in the slide, and also an indication that certain sectors are going to be favourable over others. So on the next slide, the case that is going to be really of interest is the recent referral of the proposed subsidy to BioNTech. And this actually is not referral of a subsidy scheme. This is a referral of a standalone subsidy of 129 million. And it's the first subsidy notification by the Department of Science, Innovation and Technology, which I know is one of the big grant funders of research and development in the HE sector. And its purpose is to match billion funding coming from BioNTech in 3 new facilities, again in the key areas that have been mentioned in the modern industrial strategy. And it talks about, the notification talks about the need for this investment to address market failures, to disincentivize R&D investment. Now, the subsidy was referred in the middle of October, but the report is not due out until the 14th of November. So I'm sorry we couldn't cover it today, but we are hoping to follow up this seminar with a note of the themes once the report becomes available, and hopefully it will give a bit more insight into assessing subsidies for R&D. So going on to the next section on risk management. What are the things that you can do to manage subsidy control risk? As I mentioned before, I think there's a theme that perhaps the traditional perceived subsidy risks are being replaced with other risks. What things can you do to manage the risk? I've mentioned the importance of liaising with public authority regarding the approach all the way through the process. So that's asking for their subsidy control assessment, checking that it's consistent with the view that you want to be taken. And of course, if there's treatment of a grant as a subsidy, then that obviously has to go through, is notified on the database, and quite a lot of information is made public. And then the importance of carrying out your own self-assessment at each stage of the decision-making process, so that you could understand the risks and perhaps to challenge the approach that public authority is taking. Some public authorities will have in-house subsidy expertise, but not all of them will. And there's also an issue of resources. So it's not always the case that the approach that the public body is going to take will be consistent with your approach. And if you're dealing with a grant funding application, we always suggest including provisions making it the responsibility of the grant funder to notify the transaction and to let you know when that is available. And obviously you'll need to make sure that you check that there isn't any commercially sensitive information that is going to be released. I'm just conscious of the time. I want to allow a few minutes for questions and answers. So watch your space regarding the 2 cases that I have talked about. Subsidy control regime is still developing, and I hope I've given you a flavour of where it's gone to date. It is quite a complicated specialist area, so I flagged the importance of getting specialist help, as you might expect me to do, and also, as always, the importance of having an audit trail. If you've got any questions, happy to take them now, or if you have to leave, please drop me a line afterwards and I'd be happy to answer those. If you can put any questions in the question and answer box, that would be great.